The media party and the Harper government, that is the topic of tonight's byline. Did you hear about the major loss the Harper government got at the Supreme Court today? The major loss that didn't happen? See, the Supreme Court had a ruling that's really quite minor. It clarified how an existing law should be read. Now, I might disagree with the court's ruling, and I'm often an outspoken critic of the court, but in the grand scheme of things, this is minor. Except to the media party types and their agenda, which is attack the Harper government on all fronts. So what was the media party putting out there? Well, the Globe and Mail's headline this morning read, "Supreme Court quashes Harper government tougher sentencing rules." No, they didn't. And then their justice writer, Sean Fine, that's his actual title, by the way, well, he opened his story by writing, "The Conservative government's tough on crime agenda has suffered another major blow at the Supreme Court of Canada." No, it didn't. How about Canadian Press, the wire service? Did they get it right? No. Their headline at cbc.ca, "Supreme Court softens Tories' tough on crime sentencing law." That's better than the Globe, but still not exactly true. They opened with this, "The Supreme Court of Canada has once again softened the Conservatives' tough on crime agenda." Even that, better, but not quite. So what did the court rule on today then? Well, they settled the dispute between judges and the Crown over how much credit can be given to criminals for time served before sentencing. See, a few years back, judges across the country were becoming very generous, liberal, you might say, in handing out extra time for the time spent behind bars awaiting trial. What started out as 1.5 days credit for every day served before sentencing became 2 days, then 3, and in some cases even 4 days. So a convict sentenced to 4 years for their crime, but who had spent 1 year in jail during the trial, well, they could be released the day they were sentenced. It was craziness. So along came the Truth in Sentencing Act, which said no more. The standard was to be 1 day credit for 1 day served before sentencing, meaning if you get your 4-year sentence and you served 1 year in jail, then you spend another 3 years behind bars. The law also said, though, if the circumstances justify it, the maximum is 1.5 days for each day spent in custody. Now, a couple of points here. First off, the fight in the court was over what circumstances were justified. Judges had one view, the government had another. The Supreme Court wrote what? Well, they said, look, the text of the law passed by Parliament does not limit the circumstances that justify granting credit. So essentially, they sided with judges. No surprise, they are judges. But the court didn't strike down the law. They didn't change the law. In this case, they actually did what we pay them to do, interpret the law. So how then is this a major blow to the Harper government's tough on crime agenda? It isn't. The old days of 2, 3, or even 4 days credit for time served, they're not coming back. The maximum time a convict can be credited is 1.5 days for each day served. Now, I expect to see judges to start handing those credits out like Pez dispensers, but so be it. Parliament can change the law again. Will they? I don't know. We'll wait and see. But here's what I remember. What I remember is that the NDP supported this bill. They too believed back in 2009 that Canada's judges were taking too many liberties in handing out light sentences for serious crimes. They knew that criminal defense lawyers were clogging up the courts with pretrial motions and delays so that their clients would serve as little time as possible. So the NDP, under the sainted Jack Layton, voted with the government. In fact, the NDP supported a lot of tough on crime measures back in the Conservative minority days because they knew average hard-working Canadians, including plenty of their voters, were getting fed up with a criminal justice system that gave little justice but coddled criminals. Is that what you're seeing in any of the coverage out there? No, you won't get this anywhere else because it doesn't help the attack on all fronts of the media party. It's like when the Supreme Court rejected Justice Nadal recently. It was a ridiculous ruling, but it was cheered on by the media party, and they called it a slap against Stephen Harper and his choice. They ignored that the opposition parties, the Quebec Bar Association, the top judges in Quebec, and plenty of others had a hand in drawing up the short list that Justice Nadal was chosen from. Far better to use that decision to attack the Conservatives. Today's ruling upholds the law, but it interprets it differently than the government would. And there's a world of difference between that and the media party line. And that's the byline. Our top story is the Supreme Court ruling, and Tom Brodbeck is a reporter, columnist that's covered justice issues for years now with the Winnipeg Sun. He joins us now. And Tom, this is an issue that you watched closely in the lead up to the 2009 law being passed. This was something that had a lot of Canadians worried. It wasn't just a Tory tough on crime agenda, was it?
No, absolutely not. As you said in your monologue, that things got out of hand with the extent to which courts were giving out pre-sentence additional credit. The law before 2010 was completely ambiguous. It simply said that courts may give out pre-sentence credit for time served. And it didn't in any way give reasons or give any kind of guidelines for how that credit would be given out. So courts took it upon themselves to make what we call judge-made law. It started to be, two years for every year served. It started to become, in some cases, 3 years, and in rare cases, 4. So most Canadians I know were outraged by this. People getting a 6-year sentence, and they spend a year or two in jail, and they're getting triple the time.
We've got that.
So that got fixed, right?
One of the Toronto 18, Ansad Ansari, he was released the day he was sentenced because of his pretrial credit. And that's the sort of thing that drove Canadians nuts.
Absolutely, and Canadians who are not extremists, who aren't right-wing, crazy nuts who want to lock everybody up.
You're talking about me now.
People wanted some common sense brought into the equation, and it was brought in. And it was actually a fairly mild, a fairly reasonable amendment that was made to the criminal code, and it simply said that it should be generally 1-for-1 credit. So if you spend a year in remand prior to your trial, you get a year credit. And then it says also, if circumstances justify, the court can give 1.5 years for every year that was served. They left it ambiguous for a number of reasons. We can get into a whole discussion about that, but that was left open. There were no restrictions placed on when or how or under what circumstances the court could go either 1 or 1.5 years. Supreme Court. By the way, judges right across Canada had different opinions on this latest Truth in Sentencing Act and how it should be applied. The Superior Court judges across Canada had different views on it. Some thought 1-for-1 was the norm and should be. Others said no, the norm should be 1.5 because of these other reasons. Supreme Court Canada comes in and says, look, we have to make the law and we have to standardize this for the country. And that's all they did. It was a straightforward reading of the law. And it was not the Supreme Court of Canada somehow taking pushing back the tough on crime agenda by the federal government. It's ridiculous.
I am a very harsh critic of the court. People have told me, tone down your comments about the court, you'll be held in contempt, or be said that you're in contempt of court. Well, I hold them in contempt, so guilty as charged. But in this instance, they actually just did what they're supposed to do. Part of their argument is that if you are held without bail, a lot of people can't afford bail, and so in those instances, your time spent in pretrial custody doesn't count for your getting out early or early parole, and therefore it's harsher sentence than someone that can afford bail. You know what? Maybe that's justifiable. Those were the arguments presented to it, but their ruling was succinct. Do you think, though, Tom, that the government, if it gets out of hand again, that the government should go in and perhaps describe what those extenuating circumstances should be when 1.5 days per each day served before trial, when those should be given out, when they shouldn't be?
Absolutely, and they might have to. But let's remind viewers that they put in a hard cap of 1.5, so it's never going to get out of hand to the extent it was before when you had 2, 3, 4 years. So the measures they put in place were good ones. I thought they could have gone farther, and we often criticize them for taking baby steps on justice reform. They took a step. It was certainly a step in the right direction. We've eliminated now the 2-for-1, the 3-for-1, the crazy 4-for-1 in very rare circumstances. So there's a hard cap of 1.5. I suspect now, because the Supreme Court of Canada has ruled as such, that 1.5 will be the norm. The government can come back at a later date and change that, and they could start giving some guidance to the courts and prescribe in law when and how and under what circumstances extra credit should be given, because they've been silent on that. When a government is ambiguous about law, and how they draft legislation, they know that it's then up to the courts to interpret it. And I've often been critical of government when they leave laws open to interpretation by the court, because it's sort of a weasel way of approaching the law. You're not setting out the terms under which the law should be applied in courts. You're allowing the courts to do it, and I think that's wrong. I think Parliament should set out clear guidelines, clear rules in law, in the Criminal Code of Canada, that stipulate when and how extra credit should be given, why it should be given in some cases and not others. Because right now it's left to the court still, and I think that's wrong.
All right, Tom, we'll put it to the audience. Let them have their say. Thanks for coming by.